Hello, this is John Milburn for Laws 12060 Trusts. We're into week 12. Next week, I believe, we have our exam. I understand it's next Tuesday or Wednesday. I think it's the 8th of June. But bear in mind that whatever exam I might tell you is always subject to you checking through the university site. I think it's called My Centre. Can anyone help me with that? Because you probably know I don't have anything to do with the exams other than write it and then mark it. But in terms of the logistics, that's for others, and I don't want to say something that's wrong. So we've got the chat facility. Erin says, yeah, that's right. So My Centre. And look for your individual information about the examination. Now, you can, as you'd expect, I think almost everyone has the same information, but sometimes if you are a special needs student, for example, you might have slightly longer time to read the material. So make sure that you know where you need to go for your exam. And I think that the situation is that when you enroll in the university, you're given or you're asked to nominate a default area for your examination. So when you have an invigilated examination, you know where to go. But I believe that with an application, that can change, but I can't say whether that's too late or not, and I don't know if that's the right information. So all I'm really trying to say is, I'm sorry I'm not helping you much in terms of the logistics for the exam, but I am saying make sure that you check it out now. If you're having problems, please ask through UCrew, and collectively we'll find a response, or you can ask Learning and Teaching Services. They might be able to assist you as well. Now, does anyone want to unmute their microphone and give us some information about what they've learned about the examination? It may be relevant to others.
Well, I did say that I was wondering whether we could look at the retention of title clause in 3 ways, like say at
I'll get to that. I'll get to that in a sec, B. I'll get to that in a sec. I thought people might want to talk about that obscure topic tonight, but I just really wanted to confirm about the logistical side of the exam first. So we'll come back to retention of title, and I think from what I heard from B, that sounds very good. Does anyone want to say anything about the logistics of the exam? They know where to go, when to be there, how long it takes, what they can take into the exam. Yes, Peter?
I think it's on, is it Thursday at 2 o'clock? Thursday, 3 hours, open book, so anything that you can take in a wheelbarrow, nothing electronic.
All right, thank you. So Thursday, thank you very much. All right, so make sure you're aware of that, and if you're not, ask the question now, not the last minute, and don't miss the exam. I've had a situation, I think, once where somebody said, I missed the exam. So, you know, what do I say? It's on you. It's on you. It's not, I don't have to sit the exam. I wrote it.
Make sure you're there early too, because the 15 minutes starts before the exam starts. So
okay.
It starts at 2. It's at 1:45 that you've got to be in there.
All right, good. Thank you for that tip, Peter. Any other sort of general logistical tips for the exam? Make sure you take a few pens. To set the bar exam, I had to handwrite examinations. Hadn't done that for years. It was a lot of fun. It was great.
Well, you actually have to be there half an hour early, because they let you in half an hour early, and then 15 minutes before it starts, you start reading. So you may want to settle down first and fill up your names and put in the stickers on your papers. Good
idea. Excellent. Have everything lined up. Have that bucket load of material ready to go.
Well, that'd be nice if the exam coordinator in Noosa would let you do that.
Oh, what does the exam coordinator at Noosa do?
They don't let you in until just before the start time. Won't let you even fill out your names on the exam papers or stickers until your perusal time. It's like, I just start doing it.
And then if you ask,
Can I just go, sorry, it's not part of the exam conditions.
Exactly. And then if you say, look, I was disadvantaged by a minute or two, I'll go, well, I don't care. And I mean that jokingly. All right. Okay. Well, thank you very much for that. Now, does anyone have any topics that they wish to talk about? Let's start with retention of title. B, I interrupted you before.
I'm just quickly getting my bit in because I'm going to spend half this lesson driving, so I won't be able to contribute.
Thank you.
So I was going to look at it from 3 points of view: from the common law, which is your regular return, which is contractual law, which is common law, and then from the trust point of view, where, you know, in certain situations you end up creating a trust, and that'd be really helpful because it saves you from the creditors. And finally, from the statutory point of view, where the PPSA comes in.
Perfect. That would be an excellent way to approach a question, if it happened to be on the exam, in relation to retention of title clauses or remalpa, which is becoming much less of an obscure topic than when I first announced it as being obscure. So that would be an excellent approach. Thank you, B. I really like that. One of the reasons I like that type of question is it looks deceptively simple. You know, if there was a question that said something, explain the interaction of trusts law in retention of title principles, or principles of retention and title, or something along those lines, you've got to be careful not to put the blinkers on. And I like it when you look at the question and ask yourself, is this a contract question? Is it a consumer law? Is it trusts? Is it statutory? So the whole range of things. And while your main focus may be in a certain area, you've got to at least identify, to do well, the other areas. And I think if the question is broadly termed and not specifically directed at trusts law, even though this is a trusts subject, don't be afraid to do what B has suggested, and that is introduce elements of common law or statutory law. People might say, oh, that's a bit unfair. If it's a trusts exam, we should only deal with trusts law. Just so you're on notice, I don't look at it that way. Those of you that had me for introduction to law will know that I keep talking about the sort of holistic approach that you need to adopt, and that you need to be very careful about having the blinkers on and thinking, well, this is clearly an issue that relates to constitutional law or administrative law or equity or whatever it might be. You've got to think in broader terms than that. And given that this is a second year subject, I think it's perfectly permissible to ask for you to consider those broader aspects of it. Okay, thank you for that contribution, B. Does anyone else have any questions or comments about retention of title or the exam generally? But we'll stick with retention of title first, if anyone wants to advance that topic any further. And B said they're very friendly at Bundy for the examinations, so that's good. No one else? All right. More generally, do we have any questions or comments about the examination? I should look to see if I had some notes. Yes, Brent? Was there something there? Yes.
It's not specific about the exam. It's just about on varying of trusts. I read a lot of the cases you told us the other day. If all the trustees and all the beneficiaries and everyone involved in it approve the change, why do they have to go to the court?
Well, it happens sometimes.
Yeah, I just noticed a few of the cases, everyone was in favour and they got turned down. So they should have kept their mouth shut and just did it themselves.
Well, you know, I'm sure it happens all the time. But I'll give you an example of something that I do quite regularly is deal with issues to do with powers of attorney and guardianship and administration and make decisions in relation to those sorts of things. And it may be that all the people that are involved in the process of decision making are in agreement that this is an appropriate course of action. And this is off topic, but for example, it may be that the person who is now unable to make decisions owns a home, and the family have a group meeting and say, well, we think the best thing to do with that home is to have someone move in rent-free to look after it. You know, and those sorts of things probably happen all the time and we don't know about it. But if that type of arrangement comes to a tribunal, the tribunal will essentially say, well, we don't necessarily care what everybody says or agrees. We're going to apply the law to the situation, and the law says this is the way we must approach it. So I guess that's maybe a off-topic grant, but a parallel situation where if there are rules, then there are rules, and if it's necessary to make the application, then do so. But Yeah, I take your point.
Thank you.
No other questions or comments? And as we speak, I'm calling up to see if I actually did have any notes. I thought we'd have lots and lots of questions, so I don't think I prepared anything for today as such. I take it that you had a look at my notes about examination technique. You found that on Moodle? Yes, Brad?
Yep. You've been rather, how can I put it in a nice way?
Just put it.
The style of question that you've put forward as to what will be asked.
Yes.
When you look at the tutorial questions, I guess to assist myself and my colleagues would be to consider how those questions have been broken down into, what is a fiduciary obligation of a trustee, and then how would that then apply based on these facts. Mm-hmm. So you're going to do a set of facts. I'm just trying to find your general question. But when I looked at last year's exam and the one before, it sort of talks about, has someone validly been appointed as a trustee, effectively retired as a trustee, been removed as a trustee. Mm-hmm. I'm assuming you'd want to, sort of have some sort of an outline of an answer prepared as to what are the requirements of a trustee, how do you retire one, how would you remove one, what's a valid appointment, sort of have a clear idea of what that is, yep. And then essentially apply the facts and the relevant case law subsequent to those standard answers that I'd have. So we'd sort of know, which cases apply to those certain sectors is then going to give us a better, because obviously to answer 5 questions in 3 hours, we'll be burning a bit of ink and paper. Mm. And you'd want to be rather well organised in how you're going to answer it. So obviously the relevant, so we're going to use an IRAC system. Mm-hmm. Obviously, you identify the issue. Well, we're not going to know that until we see the question. But we've sort of got a bit of an idea of, well, what's the relevant law? What's the cases that apply to that relevant law? And then how would we then apply it, and what's our conclusion? Mm-hmm. So am I reading into between our tutorial questions, and I've got a list of our tutorial questions here. I was trying to work out which ones are similar to the style, and you've been rather general in respect, which I can understand. It's an exam, it's not an assignment. And to really go through and sort of see how you've broken down some of those questions in regards to, there's one here that says, how do the shares apply to the niece, and those sorts of things. So sort of try and break down our tutorial question into essentially what's the relevant law that's applying in that section, mm-hmm. and sort of structure ourselves a bit of a, what are the obligations of the trustee? What is a fiduciary obligation? What's the entitlements of beneficiaries to challenge the trustee's decisions? Those sorts of things is then going to give us a fairly good structure, mm-hmm. to then have a little bit of a set answer and get a bit of a few runs on the board, as to say, and get the right cases. And then really then it comes down to us being able to identify the issue and apply those into a conclusion as such. Look,
absolutely. And I would certainly encourage you to do as Brad has said, and prepare much of your answer ready to go. That way you can word it just the way you want. The cases that you intend to refer to, the sections of the Act that might be relevant. If you think about applying the, say, IRAC method to the question, the IRAC method, then if subject to identifying the issues, then the next step is setting out the rules. Well, there's really every chance that you have that part of the question ready to go. And it might be rewriting the question or doing so in shorthand, but you should have the key areas set down and you should have your component of the proposed answer ready to go for rules. Back in my day, everything was closed book. So, for example, in equity, we would have done a 3-hour closed book exam at the end of the year. But I still prepared my basic rules. I mean, you just had to remember it, that's all, through mnemonics or whatever technique you wanted to use. But the same principle applies. You've got the advantage of being able to write the material out and take it in with you. So definitely do that. And I like the idea of approaching it from the Iraq method. Having your answers to the weekly problems would be a great advantage in terms of thinking the logic through. Okay, so thank you, Brad.
I was thinking for every sort of thing that we want to do, you know, they ask you, is this possible to be done? I would first say, look at the trust deed, then look at the inherent power of the court, then look at the Trust Act, and then look at other acts. And I would just go that way.
Yeah, and then the cases, and then finally perhaps the commentary from academic writing. No, great, and really logical way of approaching it. Thank you, B. Any other hints, questions? All right. Look, I have discovered that I prepared notes. I did want to cover something tonight. I said it would just be revision, so I hope you don't mind if I just make a few comments about equitable compensation. It's been an area that we've skirted around equitable compensation a bit, but just be aware that there are remedies for breach of an express, resulting, implied or constructive trust, and that can be all through equity. Have a look at a case of Yuang, Y-O-U-Y-A-N-G, Proprietary Limited against Minter Ellison Morris Fletcher. It's from 2003, 212 CLR at 484. And I've mentioned in the past that the remedies that you seek can be pleaded as an alternative, and equitable compensation is a remedy that can be generally pleaded as an alternative for a claim for breach of contract or the commission of some sort of tort, as well as some other equitable issues. So that's something that a compensation in equity in general terms is to restore an injured party to a position that existed before the wrong and to uphold an obligation that's been breached. So that's generally what we mean by equitable compensation. It's a very broad avenue of attack. Other things that you can consider, and we've talked about this before, an account of profits, which is an alternate remedy to damages or equitable compensation. And a bit the way that B was talking in terms of layering, when it comes to thinking about the remedies that might be available to you in certain circumstances, try and layer your thoughts and be prepared to argue for the alternate remedy. So it may be, for example, that you argue that damages is an appropriate remedy, but failing that, you can ask for equitable compensation, or maybe before that even an account of profits. So these things can be presented as remedies, alternatives. Sometimes you do need to choose. Sometimes you do have to make a clear decision as to which way you're going to go. But generally speaking, you can plead in the alternative. So that Minter Ellison Morris Fletcher case is one to consider. And there's another one where we're talking about an account of profits, which is Console Development, Pty Ltd. That's CONSUL Development, Proprietary Limited against DPC Estates, Pty Ltd. 1975 132 CLR 373, and that dealt with the issue of account of profits in intellectual property cases, where it's described as notoriously difficult, and sometimes, and the reason I'm telling you this is that sometimes the courts will say, we can't exactly work out what is the figure, so that's not sufficient to refuse the remedy, but we will just work around that as best we can. So keep that case up your sleeve in case you're really stuck and you can't work out what is the appropriate dollar figure. Then think about that concept, that principle from Consort Development against DPC estates. Another thing that may be relevant is contributory negligence, but you shouldn't have any concerns about that for the exam. Now, I wouldn't expect that there'll be a specific question in relation to the commercial aspect of trusts, but do we all know what we mean now by a discretionary trust? I'll give you a quick quiz. So if anyone doesn't know, then speak up and we can talk about it. So I've just got a list of questions that I think you should probably know straight away. Right, so does everyone know what a discretionary trust is, just in general terms, and why we have it? Good? All right. Do we know how we change a trustee? Okay. So we know that the trustee must resign or be removed, and we would normally have that in writing. But again, as B suggested, look at the trust deed first, because that will normally dictate the method of changing a trustee. And do we know about the power of appointment? We know what an appointor does? Yes? So a trustee can be removed. The appointor can remove a trustee and appoint a new trustee. And most discretionary trust deeds provide for that. So again, it's built into the trust deed. So when you have an answer to a trust's question, even if you're not furnished with the trust deed, really good idea to, if there is obviously going to be a trust deed, say subject to the terms of the trust deeds, this is my advice. So if you don't know what's in the trust deed, don't ignore it, but acknowledge that it's there and say that your answer is subject to anything that might be in the trust deed. Okay, now the next question, do we know how a trustee is added? Can anyone tell us, is that good? Again, it might be through the power of appointment. Same thing, in the same way that an appointor can remove a trustee, they can add a trustee. So they don't have to add a trustee to replace the existing trustee arrangement, they can supplement. I think there's a limit on 4 trustees though, so just be careful about that. All right.
That's only with a self-managed super fund pursuant to APRA and SIS.
Yeah, I thought
it's a small fund, but a larger fund, you can have a corporate trustee with majority shareholders.
Of course, it's still only one trustee though, isn't it, if you have a corporate trustee?
Right. But I would have thought with a family trust or discretionary trust, I didn't think there was a limitation.
And
I know there is.
And it's just, it's something that has just occurred to me, and I'm thinking now I've been doing a lot of powers of attorney work, and now I'm thinking, oh, maybe I'm thinking of something under the Powers of Attorney Act. So just be prepared to scrub that last comment.
Appointors are generally limited under the terms of a deed, I think.
Yes, and that's exactly right. Yeah, thanks, Brad.
Can I just ask a question? That in week 9, you're rather extensive in your discussion of the Holman and Johnson tests and Chettiar and the first trance and second trance principles, and that'd be something that'd be worth knowing for the exam. Do you think, John?
Yeah, and I don't, and I'm not being facetious here, but I mean, I do so much across different, tribunal work, barrister's work, university work for different subjects. I honestly forget. So if you ask me, I've got a fair idea of what the obscure question is in the trusts exam, but beyond that, I'd be struggling to tell you what I wrote, because I wrote it months ago.
But I'm sure the jury here would allow you to refresh your memory and respond accordingly, do you think?
Oh no, but Brad, see, it sounds to me as though if you wanted me to answer that and say that it's in there, you'd be disadvantaging yourself. You'd be helping everybody else. But it sounds like you've already done the work. All right. So no. We can't do. And evidence is the next subject. So no refreshing from memory on that one. But good try. All right. So we know how to remove a beneficiary, do we? Do we know how to remove a beneficiary? Obviously, a beneficiary can renounce his or her interest. I think we saw some cases on that. Again, you've got to look at the trust deed. Most provide a couple of ways of removing. People can renounce, or the trustee can make a declaration. I mean, that's a really brave move, and the trustee would need to be very careful. And as I've mentioned a few times, always think in terms of the possibility of this being a resettlement of the trust, in which case that can trigger all sorts of taxation and duty implications. All right, if you're setting up a trust and we need a settlement sum, is there a minimum amount that would apply? I think we've talked about this in the context of setting up a discretionary trust or a unit trust. Is there a minimum? Yes, Brad?
You said 50 in your notes, but 10 was also allowable.
Yeah, 10. I think
as long as it's the first transaction, and generally people keep that in a separate account so that the corpus of settlement is retained.
Yep. Look, I think really I wouldn't do it, but I think $1 would do. But I think, you know, $10, $50, $100. I disagree slightly with Brad's statement. I think you're being a little conservative. I'm not saying Brad's wrong, but I would take a different view that provided the settlement sum is the very first entry into the bank account and it's not put into the bank account with something else, I think you can then use that bank account for other things. But Brad has the view, and I think this is right, Brad, your view is it's much safer to quarantine that settlement sum in a separate account. And I'm not going to argue against that. That's a safer approach.
That's more the commercial practice, especially in self-managed super funds. In normal business practice, it's not a big issue, but self-managed super funds, auditors tend to prefer that. Not that it's legally binding, but it just seems to be commercial practice.
Okay, and you know, I'll say it's good practice as well. Again, we're adding beneficiaries. We can do that, but again, you've got to be careful about a resettlement. The name of the deed, you can change that. You don't have to stick with the name. You can always change the name. Here's a question. In a discretionary trust or a unit trust, do you have to have a trustee? On the chat facility, I'm getting some yeses and some nos. Do you have to have a trustee for a discretionary trust, for example? Yes, says Tamara, because you've got to have something to go by. Any other thoughts? Do you have to have a trustee? Surely, says Tamara. Yes. Absolutely, I agree with Tamara. Yes. Tamara said you must have a trustee, otherwise it's not a trust. Yes, spot on. Good. Thank you. Trick question. Yep, otherwise the legal title is not separated, says Adam. Absolutely right. You've got to bear in. I guess part of the question, and the reason I'm asking that question, is just to remind you to go back to basics. If you have any uncertainty, just go back to basics and think, well, it's really got to be the case, hasn't it? And Tamara said, surely, yes, absolutely. So good answer. We have an idea of how trusts are wound up. We know roughly that there is this thing about the rule of against perpetuities, which we don't like. Nobody likes the rule against perpetuities. We know that you've got to think about trust law in the context of other laws, and we've talked about federal laws quite a lot during this course: bankruptcy, marriage, social security, PPSA. All right, so, and can the, all right, so you must have, can the set law change? Can you have a different set law? We'll get you to go back to basics. No, says Brad. You didn't put it in. No, 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 no. Yes, you're correct. Absolutely, you're all correct. You're all screaming at me. No, why can't you? Because if you have a set law, that's it. The set law settlor settles and then walks away. That's the extent of the settlor's function. Okay. All right, good. And we know about how long the trust will last, generally speaking. Okay, you've done really well this course. Very happy with the work. Great effort. We're going to finish soon. I'm wearing my maroon coloured tie for those that are interested. And I'm going to do evidence at 7 o'clock, and then I'll go and watch some football while this is uploading. All right, so all done? Okay. All right, thank you. Now, what was that? Erin says, can we have a look at, what was it, Erin? At JQ.
There were some questions on chat, John, right back towards
sorry.
the end that haven't answered.
Thank you.
Yeah, and also tomorrow's question, John, I'd like to know as well.
Okay. Sorry, I wasn't looking at the chat facility. So we've got Erin. Part B, question 1 and 2, seem very similar apart from the commercial aspect. Is that a fair statement, or have I got it wrong? I think, Erin, you're talking about the tiny little hint that I gave about what's on the exam. Is that correct?
Yes, that's right.
Yeah. You can't really read much into it. I think I've given you some idea of the individuals behind it and maybe just a little snippet to get you started. But look, I think it's probably fair to say that for the most part there is a commercial aspect. However, having said that, I don't want to mislead you in terms of previous statements that I've made that I'm not directly likely to be asking you questions about the commercial use of trusts. It's more... sorry, Erin?
It was question 1, and it says, explain the nature and effect of trust law-based concept, discuss its main characteristics in the commercial world. Then question 2 says, discuss why trust-based law rule exists and its effect.
Oh, okay, all right. Yep. They're both the essay questions. Yeah, I suppose you could say, yeah, they probably will have a commercial feel to them. Yes. So that is a fair statement. Thank you, Erin. Melissa said it's vague. It is a bit vague, sorry. B said, if you listen to week 4, John said we need resulting and constructive trusts for the exam. I think resulting and constructive trusts are always going to be pretty close. I won't be putting up suggested answers for the weekly problems. I did mention that early on, and the reason is that I want you to do your own work, and it's great preparation for the exam. Sorry. The other thing that I would encourage you to do, it's not too late, put your answers up on Moodle. That way they're your answers and you can claim copyright. Holman and Holman, Chettier and Chettier, we talked about that. Now, Tamara, I get where we've come over multiple times, but I just want to confirm, if we've been able to confidentially answer the tute problems, should we be fine for the exam? You'll be very well placed for the exam, Tamara, but I won't say that it's necessarily going to be... Well, I can say this, that it's very unlikely that I've drawn a question directly from the weekly problems. However, the weekly problems cover the best part of the course, apart from something that might be obscure. So, and I keep using this word obscure. You know what that means. You all know what that means. But otherwise, working your way through the weekly problems is a really good way to test whether you're on top of this, so that when you're faced with one of these problems, you're not going to be, you know, at least you'll have some focus. I hope that answers your question, Tamara. It's very vague, I'm sorry.
John, Sophie had a good question up near the beginning as well. She's asked, what is a trust-based law rule?
Oh, okay, all right. I'll come back to that. Just before I do, Tamara, did you want to say something? You don't have to? No? Okay. A trust-based rule might be a law that relates to, in some way, to trust laws. So it might be a statute, it might be a rule like, you know, or a principle. It might be sort of like Hardoon and Belilios principle, or Chettiar and Chettiar, Holman and Johnson. They're not statutes, but they're principles that are trust law based. Or it might be something to do with how you apply Section 8 of the Trusts Act in a real life situation. So they're all principles of trust law, if you like. Sometimes statutory, sometimes case law. Okay, other questions? I think we're getting close. Oh yes, so trust-based law of rule. More idea on where to focus, says Melissa. Yep. Okay. I think there's more questions coming through. Sorry, I'm just scanning through the questions. You've been busy typing. Well, lots of no's there. Okay. Are there any other questions? Please unmute your microphone and I'll keep an eye on the chat facility. Or are we all done? All right. I'm sure you'll all do well. I want you to do well. When you go into an exam, or when you stand up and appear in court, just remember that everybody wants you to do well. Even your opponent wants you to do well, you know, and be comforted by that. They do. They do. Opponents want you to do well. They don't want to see you dying on the stage. Your client wants you to do well. Everybody wants you. The judge certainly wants you to do well. So in my case, as the examiner, I want you to do well too. All right. Well, you've done very well. I'll end the meeting. We'll record this session. Yes.
Wait, John. Sorry, I just reached the other car park.
Yes, B.
Before I go, what is a terminable condition? Was it determinable condition? Is that the same as a condition precedent or condition subsequent? A terminable. It comes in one of the chapters near the variation, near the end.
I might have to get you to put that one on UCrew.
Okay. All right.
So I can sort of think through that one.
Thanks.
But thank you.
Yeah.
Okay.
But thank you very much. You've been a really great tutor.
Oh, thank you. You've all done very well. Been really happy with what you've done. Okay. All the best. Good luck with the exam. Make sure you know where and when and be there early. Okay. All the best. Bye then.
Thanks, John.
Bye.